Good morning, everyone. Welcome to today's webinar entitled New Tools or New Competitors, the Future of Competition Law in Canada. I'm Aaron Woodrick, the Director of the Domestic Policy Program at the Macdonald-Laurier Institute. I'm very pleased to be moderating today's discussion. We have an outstanding panel of experts joining us to discuss what I think is a very hot topic. First of all, in no particular order, we have Anthony Niblett, Associate Professor at the University of Toronto Faculty of Law. We have Tom Ross, Professor Emeritus at the University of British Columbia Sauder School of Business. We have Jennifer Quaid, Vice Dean of Research and Associate Professor of Law at the University of Ottawa Faculty of Law. And last but not least, Gail Campen, who's the Chief Operating Officer of Neuran Wireless, he's based in Paris. He's also formerly of our friends over at the Montreal Economic Institute. So welcome to all of you. Thank you so much for taking the time today to talk about this. Now, of course, this webinar comes at a time when the federal government is in the midst of a broad consultation on some potential reforms to competition law. And of course, from the public standpoint, there's a lot of stories in the news that are relevant to competition. We have a lot of customer frustration with airlines in this country right now. Of course, there was a very prominent deal in the telecom sector, Rogers and Shaw, that has made a lot of headlines over the last 2 years. And of course, a lot of concerns and a lot of quarters about the market power of the so-called big tech players and whether or not this sector and these players call for new tools, as the title of the webinar suggests. So I wanted to first give everyone some time for some opening remarks to get their thoughts on the consultation and what they think are some of the key things that should be considered. I've got some questions to follow that up, and then if you are viewing on YouTube or LinkedIn, on Twitter, please feel free. We love to get audience questions, so just type them in the chat, send a message, and we'll try and get through as many as we can this hour. So with that, I'd like to start by turning it over to you, Anthony.
Thanks very much, Aaron. Thanks very much for having me. I think it's great that the government is asking these questions, and I think it's great that we're having these sorts of conversations about the future of competition policy in Canada. I've been teaching competition policy for 5 or 6 years, and the demand for competition policy that has just gone through the roof over that time. I mean, people want to be engaged in these conversations, so I think it's fantastic. The fact that it's engaging so many people who weren't talking about competition policy 10 years ago is great. And I think there is, a good claim that we need to modernize the Act, but I think most of that could come at the margins. I'm not personally terribly convinced that the case for a dramatic overhaul like we've seen in some other jurisdictions like Europe. I'm not terribly convinced that the case has been made out. The Act is very much, the Act we have is somewhat of a product of its time. There's language in there that, very much a product of the 1980s. I think there's a very good case for increased enforcement of our current law. I think the recent changes to opening up to private rights of action, the increased penalties were important. I think there's questions about the extent to which they're constitutional or not. But I think we want to deter firms from acting in an anti-competitive way, and the Bureau needs to have the tools to the technical tools to effectively monitor and effectively deter this anti-competitive behavior. I think one of the good things about this conversation is that it's forcing us to really think about what it is we want competition law to do. What can competition law do? What should it do? And what can't competition law do? And I think we have to be a little bit careful that it's not trying to do too much, that it doesn't have too many objectives. And so the current law we have, Section 1.1 of the Act, is 80 words long, one sentence, and contains 4 different objectives. And sometimes these objectives align with each other, and sometimes they don't. And what happens when these objectives conflict with each other? How do we trade these off? How do we, who determines which policy goal is more important? And my view is that I come at this from a perspective of an economist, and my view is that we could simplify the objectives a little bit to focus on the economic harms to consumers, workers, other businesses, focusing on the economic harms to innovation. So, but I don't sense from the ISED paper that there's much appetite for simplifying those objectives. If anything, the conversations that we're having more broadly seem to suggest an appetite for expanding the number of objectives in competition policy. Take into account things like, the environment, workers' rights, privacy, harms about the restriction that come about from restrictions on speech, all of which are extremely worthy goals. There's no doubt about that. Extremely worthy goals. I just question whether competition law is the best place to be solving this problem, whether it's the bureaus that should be dealing with that, and whether competition law is just, in my own view, is that it's a very blunt tool to be dealing with those sorts of problems. And so I think we have to consider competition policy in line with this broader suite of government policies. And I think if we shift away from economic harms, then there's this fear that I have that we're going to move away from objectives that are grounded in economics to ones that are grounded in politics. And our focus should be on promoting competition, not necessarily protecting competitors. That is not what we should be doing. The competition has to be genuine competition. And competition law can't be all things to all people. And, we have to just consider competition policy as being part of this broader suite of government policies. If we agree on those objectives, then the question is, how do we best achieve those goals? And I'll turn it over back to you, and we can talk more about how do we best achieve those goals. But I think a really important question is, what is it we're trying to do here?
Yes, absolutely. Thank you for that, Anthony. Tom, let's go to you next.
Great. Aaron, thank you for the invitation. Thanks to MLI for organizing this event. I'm very pleased to participate. I'm going to say some things that are going to sound a little similar to Anthony's opening remarks. I'm also an economist, and I'm very pleased that we're going through this process of a kind of a very detailed, careful, I hope it ends up being careful review of all aspects of competition policy in Canada, with a particular focus on the Competition Act. I don't think we've had a review that is the potential to be as broad as this one for a very long time. Very early in my career, I think I'm by good measure the oldest on this panel, but very early in my career, we were going through what were called, I think, the Stage 1 and Stage 2 amendments in the 70s and then 80s that gave us the Competition Act in 1986. So that was a very, very, very big deal that completely changed the orientation of Canadian competition policy. And this, has the potential to be significant, kind of maybe not quite on that scale, but very, very, very significant in a way we haven't seen maybe since then. I think it's useful to recognize why we're at this point of looking at this. And some of it, yes, is a concern about these digital giants, these tech firms and tech-enabled firms that have grown to basically dominant positions in a very short period of time. They seem to be, it's difficult to imagine them being replaced by vigorous competition because they seem so well entrenched, even though it may have only been 10 or 20 years that they've been with us. So that this has created a set of questions about whether competition policy is really ready for the digital age to take on these firms. And that's not a concern that's not just popped up in Canada, it's popping up all over the place. The Europeans have sort of taken the lead here, creating a Digital Markets Act to help provide some additional regulation of firms in this sector. Americans are worried about, everybody's really worried about it. Every country I know with a sophisticated competition agency has looked at this. But beyond the digital, I think there's other reasons to be looking at our act. There have been concerns about growing levels of concentration and possibly higher profit margins. Generally, this has been a concern in Canada and the United States, maybe more than Europe and some other places. I want to say that the evidence here is not completely convincing, but there's no doubt there's a concern. And so maybe it's worth looking at this concern. Economists have been sort of carefully trying to study the question of whether concentration's really risen and margins have really risen, and it's not settled. But the concern is there, and it opens the conversation. And then, very particular to Canada, as will happen anytime you have a law, as years go by and courts make tribunals and courts make decisions, gaps appear. Suddenly you realize something you thought was covered isn't covered. It sort of slipped out, or a court makes a decision where everyone thought a word meant one thing and the court says no, it means something else, and now you don't like that. You don't want it to mean that, and you need to come back and maybe change the law to reflect what Parliament and the Canadian public really wants its Competition Act to say. And we've had these gaps have opened up, I would say, in the merger area, in the cartel area, and the abuse of dominance area everywhere. And so that's another reason it's time to revisit the act. Now, we have, over time, when gaps pop up, we sometimes band-aid them, and we do quick fixes that address a gap here, gap there, and that's all fine. But this is an opportunity now to patch a few things at the same time. My general view, maybe not too different from Anthony's, is that we actually do have really quite a good law. It's got the right elements in it. It's very economically literate. It's flexible, I think, so it is able to adapt to different market situations and different. I think there's a lot of potential to adapt to the digital world within the current legislation. I do think that we could, in the past, we've sort of starved our enforcement folks, and recently they've gotten a lot more resources into the Competition Bureau, and I think that's a good thing, and that can only be helpful. That said, I still see the potential to make some very interesting and what would still be significant changes to kind of tweak the law to make it even more fit for purpose in the 21st century. Some of these will be to address challenges coming from the digital space, but some will be to fix gaps that may have nothing to do with digital. Now, I guess in this session we're probably going to talk about lots of different kinds of changes that can be made. I know there'll be a lot of talk. Anthony's already introduced the topic of the overall goals of competition policy, and I'm sure we're going to get into that. It's hard to believe we're not going to talk about the efficiency defense and mergers, which is obviously a very big deal to a lot of people. I want to highlight a few things that I've been thinking about that I'd like us to consider. One is, I think a lot of good could be done by giving the Competition Bureau stronger market studies powers. That is the ability to study intensively markets without necessarily having to launch an action against a specific firm, but to do detailed studies of markets with the power to compel people to provide data and witnesses and evidence and documents so that the Bureau can get a better understanding of markets that might seem to be underperforming in a competitive sense without knowing exactly what it is and you want to charge them. And I really love the idea of adding to the market studies powers. And Canada is really behind the world in the authority we give our competition agency to do market studies. Secondly, I really like the idea of enhancing the ability of private parties to enforce the competition law. We did provide in the new amendments in the Budget Implementation Act the right for private parties to go to the tribunal alleging they've been harmed by abuse of dominance, but we don't have the ability to award them damages for that. And I think if we don't allow them to provide for damages there, that's going to be a fairly useless complement to our antitrust or competition arsenal. So I want to see damages there for abuse, but also refusal to deal, resale price maintenance, and exclusive dealing, tied selling. And the third thing I'll mention is I like the idea, this is much less talked about, of creating a second branch to the price fixing provisions, which would be a civil branch, a sort of a civil version of Section 45, the price fixing provision, which would allow the commissioner to take a case that might be a little bit challenging under the criminal law because of the high standards of proof and the inability to sort of infer agreements without really good hard evidence. I would like to give the commissioner ability to take those on a civil basis, still to get fines perhaps, but without maybe all the machinery of criminal law. Much of the world does its cartel work without criminal law, and I would like to add that to the arsenal that our commissioner has. So those are three of the things. I'm sure we'll get into other stuff, but again, Aaron, thank you for the invitation to participate here.
Thanks, Tom. A lot to chew on, and I regret we only have 1 hour because there's so much that we could go on about. Jennifer, over to you.
Thanks, Aaron, and thanks for the invitation to be part of this panel. I think the more that we have a chance to exchange ideas, the better quality policy will emerge, and I do believe that there is a great need for greater exchange of ideas. One of the things that has happened, and I'm sure everyone on this panel knows that, is that there's sometimes a tendency to try to categorize people into falling into specific views or perspectives on things. And I don't know that that's always very helpful, because I think the person who is thoughtful about things may, in fact, not really fall squarely in one camp or another, and may have a range of ideas. And I think we're already seeing a little bit of that in the discussion so far. I'm going to try to talk about some different things than what Anthony and Tom have talked about, not because I'm not interested in the things they talked about, but I'm trying to sort of expand the topics for conversation. I do think on the consultation and the moment in which we are, where this consultation is happening, and the expectation there will be a second phase of reform. The first phase having been this small number of amendments that were included in the Budget Implementation Act last spring, and were enacted without any changes, despite many efforts on the part of many people to suggest that there could be some modifications. I truly, truly hope that the second phase will be the subject of a bill on its own, or a piece of legislation that can actually go through the normal course of review. That may sound, like somebody who's feathering their own nest, because I'm interested in those policy discussions, but I do think that it would be nice to not have the time pressure of a budget bill, and essentially the sense that you are in a futile fashion offering suggestions that just won't have any time to be integrated. But I do think we are in a moment, and like Tom has observed, and also Anthony, what's exciting for people like me, I may not be the oldest person on the panel, but I've been in and around the competition space for a quarter century, and I can tell you I've never seen the energy that is there right now, and that's good. We need to harness that energy, that enthusiasm, that interest on the part of the public. We can have different opinions about the impact of the Rogers-Shaw merger and the 2-year saga that has unfolded in the media and elsewhere, but it has raised attention and gotten people interested for a variety of reasons. And I think that we should try to build on that. I do also think that we are at an interesting moment in the economic development of our country and of the global economy, and you can't pretend that that's not happening. I have struggled to find the right expression. I call it digital transformation, because it's not really just economic, and there isn't a digital economy and another economy. The economy is one thing, and it integrates a lot of the things that have happened over the past 20 years, let's say, that increasingly draw on features of techno-scientific capitalism. So the integration of data and digital features into the market, artificial intelligence. At the same time, sometimes these things are not actually that different. They're just in a digital form, so they build on things that have happened before. And I think there has been progress, but we still need a lot more research and analysis of what's going on and what that means for competition. So I'm excited if this process can generate that evidence, which brings me to my first sort of hope for this consultation, which is that there will be evidence. I, like Anthony and Tom, am somebody who is interested in, research and rigor, and I find that often absent in these debates is a real habit of relying on evidence as opposed to speculation or opinion. I would like to see, and I think it's incumbent on all of us to provide substantiation for what we're saying. So where is the economic evidence that concentration is or is not a problem? How is it a problem? And what might be the solution? So I think that that's important. We need to think about how we develop policy thoughtfully. The second thing that I'm interested in, and maybe is different from some other people on this panel, is that I think that competition is in conversation with a larger number of policy objectives, which is not quite the same thing as saying we should modify the purpose clause. We can talk about the purpose clause if you like, but I'll leave that for the discussion. I do, however, think that the way we regulate and the way we undertake the creating the framework for economic policy needs to be shaken up. And I do think that competition is a piece of a larger puzzle and needs to be in conversation with that larger puzzle. We do have cases where it straddles considerations of privacy, competition, data protection, and in our lovely federation that we have, that adds a provincial federal dimension as well. We need to think about how we coordinate these various entities that are involved in providing a framework that balances the promise with the risks of what is happening. And I don't have a magic solution, but I do think that competition can't be at cross purposes to some of those larger objectives, whether or not we choose to integrate them into the purpose clause. And I will name them because, I'm that kind of person. I do think we have to care about inclusion. We have to care about reconciliation. We have to care about the climate emergency. Maybe those aren't priorities of competition law directly in the Act, but you can't have a competition policy that is working against those larger objectives. So we need to think about that, and we need to contend with that. And if there's one thing that I've noticed in the surge of energy that's happening here, it's that there are people half my age who are really engaged and want to do something about this. And we have to keep in mind that generational concern. This is a generation that's grown up in a different mindset and with a different sort of set of realities than I did at their age. And I think we have to respect the fact that they may not share our view of how we compartmentalize regulation of the larger issues. And finally, because there's many things I could talk about, I agree with Tom that we have to be mindful of the fact that the Competition Act has not been amended since 2009 in any substantial way. I leave aside the amendments of the spring, and I'm happy to talk about those because I both agree and disagree with some of them. But I think we have to be aware of the fact that there are some long-standing structural issues and legacy problems with the Act that we have an opportunity to address. And the one I'm going to put on the table is the tribunal, because I think that the Rogers-Shaw merger, among other things, has highlighted the fact that we have a decision-making body that I am not sure is the ideal for what we would like to accomplish, which is rapid decision-making that is expert-informed. What we have is a court. And trying to hurry up a court is not necessarily the best way to structure things. I think we should really open the door to other models and other ways of providing decision-making on civil matters, of course. And I share Tom's concern that the criminal provisions really are, and I'm a criminal lawyer, so I think that we have to be careful about relying on them too much and expecting too much out of them. And I really like the idea. I didn't know that you liked that as well, Tom, of civil provisions that are sort of based on the model of the cartel provisions. So civil per se, I think that that's got some interesting legs. I'm going to leave it there for now, but happy to talk about many other topics.
Great. Thank you, Jennifer. And Gail, over to you. Oh, you're on mute.
Thank you, Aaron, and thank you for the Institute also for inviting me today. I have a couple of things to say about this. I'm the non-Canadian, part of the team. I have a big international experience with business, especially in telecom. But like you said, I was also an economist, senior researcher with the Montreal Economic Institute, so I have good knowledge of the Canadian market. And there's two things I would like to say. The first thing is that this is old debate. Okay, we've been talking, competition policy for 250 years, basically. But the terms for me haven't changed that much. When it comes to enduring leadership, because I think that's what people are raising an eyebrow for, how come somebody becomes so strong and so powerful in a specific market for so long? When it comes to enduring leadership, for me, the two important questions you need to ask yourself is, how did it get there? Which means there's two possible causes for enduring leadership. One is continuous improvement from the part of the leader that keeps bringing innovation and value for money to the consumers. And the second one is some kind of government protection that prevents, competition from happening the way it could. That's the first question I ask myself whenever I see enduring leadership. The second remark I would like to make is that we're talking about government, we're talking about policy, and the key for me, the key in this discussion are the consumers themselves. And I like the old-fashioned concept of consumer, sovereignty. Sovereignty is not with the government in this specific case, it's with the consumers. And we don't speak enough about consumers that I think are the main beneficiaries of both, competition and the laws that, maintain it. And also the first victim of the laws pretending to maintain it but actually enforcing some kind of cartelization through licenses and laws that are very difficult to follow, especially for foreign competitors that find it hard to penetrate the market, either because they are banned, just by being foreigners, or because the intricacies of the regulation as such, but if you don't have 5 years in the business, you cannot comply. So these are things I think we need to keep in mind. And it doesn't matter, the good intentions of the law. I believe that by the time, if it's too encompassing, if the objectives it pursues are too large, if it's too specific in the way it wants to define the market today, I believe that by the time the law is enacted and by the time the tools to enforce it are, ready to be put in place, the law itself will be obsolete, at least, to some parts, because markets are very dynamic. Things are changing very fast. Whoever you think is strong today is going to be weak tomorrow. We can also have a long list of formerly, dominating competitors. Let's name, BlackBerry, for example, to hurt the Canadian pride a little bit. People that were overly dominant for a certain period of time and just disappeared from the market, which means you have to trust that customers can actually, throw under the bus whoever they were idolatrating, the year before. That's their job, and that's for them that we are looking at competition and the laws to maintain the right level of competition. So that would be my perspective on it, to keep the customers at the center of the agenda, not the public, not the law, not the government trying to enforce it, but the customer themselves, and understand whether it's benefiting them or not, and whether the government is not the firefighter, which actually the arsonist, creating the situation that actually limit competition while coming afterwards to complain that some players have become too big just because they didn't let foreign or local competition enter the market and compete with them. I'm just going to name one example. I completely agree with all the concerns regarding privacy issue, the use of data, and all these things that are happening through the digital economy today, which are not part actually of the original contract by which the customer engage with these entities. And I think it's more about contract law, tort law, criminal law, that this issue could be addressed, and not so much through competition law. But that would be my point of view about this. And one last word: if you look at companies like Facebook, for example, that was overly dominant 5 years or 10 years ago, with disappearing from the market, slowly but surely. Nobody under the age of 20 today is on Facebook. In 5 years now, it's going to be nobody under the age of 25. It's only old guys like us that's still using Facebook. And in 5-10 years from now, it's going to be gone, and somebody else is going to come in with a new product, new innovation, new angle, new stories, new ways to engage customers that we cannot imagine now, that the law cannot imagine, and the lawmakers cannot imagine. And this is what you don't want to prevent. You don't want to prevent newcomers to, take away the current leaders by bringing better, cheaper, faster solution to improve the Canadian customer's life. That would be my angle on this topic.
Thank you very much, Gail. Put you firmly in the camp of sticking with the consumer welfare standard. I've got a couple of follow-ups for each of you, and then if anyone else would like to weigh in after, that's very much welcome. Anthony, I want to start with you. I mean, you make the point that we don't need drastic change, and we've heard a lot about perhaps a different nature of big tech or the digital economy. And I guess the question that I think a lot of critics raise is that one of the differences, and I think Gail touched on this, is that it's not just about size anymore. Sort of being dominant, being a monopolist used to be about size, and now it's also about information. It's about data, and it's about information that some of these large entities may be able to capture or have that competitors or prospective competitors don't have. And is that a fundamental difference? Does that call for different tools? And is that sort of what's behind a lot of the calls for new tools? Because they just think that there's fundamentally something different at play with a lot of these digital tech players.
Yeah, thanks, Aaron. So I think, Jennifer raised a number of great points when talking about this. You know, these large digital players are affecting all sorts of things outside of what we consider are the economic harms of competition. You know, so from a competition perspective, there's additional concerns that come out of these large digital players. You know, you talk about the access to data. Essentially, you talk about raising barriers to entry. You know, with the digital in the digital economy, we've got increased focus on things like network externalities. You've got enormous economies of scale that come out of this because the marginal cost is essentially zero for a lot of these products. We've got concerns that are being raised about two-sided markets that leads to all sorts of potential concerns. And so you get these digital markets. There's an increased focus on competition for a market rather than competition within a market. And so it could be this tendency to, so the theory goes, that you end up with, you know, a small number of players, very large players in a given market. And there's no doubt that that the rise of these firms, you know, most of these firms didn't exist 30 years ago. The rise of these firms has contributed to this bright light on competition law. But when you look at the economic harms and you look at these competition questions, I'm not sure that there's that much that is new if you decide to focus on these economic harms and competition questions, these genuine competition questions. We've had cases about two-sided markets. You know, when newspapers are an example of this. We've had cases about access to data. You know, the Bureau brought a case against Toronto Real Estate Board for abusing its dominance when it was restricting access to its data. You know, we can bring claims like that under Section 79. We have the law, we have the tools. Now, there might be a concern that it's slow, that, you know, it takes a while it's costly to enforce these things. You know, there's this concern about self-preferencing, which comes out of the ISED report, and is something that they're dealing with in the Digital Markets Act in Europe. And I part of my response to this is I don't think we want, and this is kind of aligned with what Gail was saying, I don't think we want bright line rules that will be a product of its time. If we implement a suite of bright line rules telling people what they can and can't do, then this dramatic overhaul like we've seen in Europe, then I think, you know, that law will get pretty antiquated quite quickly. So we talk about self-preferencing, this idea that you have a platform and you're selling your own products and those of your competitors as well. You know, that can be anti-competitive if it forecloses efficient competition, you know. But there's a lot of benefits that come from this sort of behavior. You know, and the example I often give is, you know, if I'm searching for a hairdresser on Google, you know, it'll give me a Google map of all the, you know, the hairdressers, and so that's better for me because I have, you know, the search and I have the map, and, you know, it's beneficial to tie these things together. You put a ban on self-preferencing, who knows what it's going to capture? Like, it's a really difficult phrase for a term to define. And, you know, I've got this paper coming out that looks at the differences in how people define self-preferencing, and you get a broad range of definitions, a huge range of definitions. And the problem for bright line rules is you have to be very clear about what it is you're prohibiting. You have to be very clear about what you can do and can't do. And so, as Jennifer says, there's no magic solutions. I don't think there are easy answers here. And what I like is our law is quite flexible. I like the fact that we've got a very flexible standard in abuse of dominance. Yeah, there are problems with it. It's absolutely not perfect. And Tom raised some of the problems in the way the laws have been interpreted. But it's flexible. It deters anti-competitive effects. And so I think the focus needs to be on effects. We want to deter anti-competitive conduct. We don't want to just deter conduct. And as Gail says, we really don't want to deter innovative conduct. And so I think there's a really good argument that we should be kept flexible. And just to follow up on what Gail was talking about, we often focus on the problems that digital markets create, and that's exactly what we should be focusing on, the harms. Gail also mentioned, you know, there are one of the characteristics of digital markets is they're constantly changing. They're changing rapidly. The market definitions change. They're fleet very quickly. And so this market power might be more fleeting than we think, potentially. If you look at the Apple case against Epic, the judge basically says, well, this is the market, but it might be very different in 6 months' time with these new competitors. There's constant innovation. The markets are in flux. There are new competitors that come and disrupt the market. Gail talked about Facebook. 2 years ago, that was all we were talking about. Now Facebook isn't even in the top 10 by market cap because of competitors like TikTok. You look at what is probably the closest thing we have to a monopoly in the digital economy, and that is Google's market power in search. And just this week, we've got this new disruptive competitor. Bing are introducing this Chat GPT, essentially changing the way that we'll be thinking about search. So who knows, in 1 year's time, 2 years' time, we might be thinking about, do you remember that time when Google had all that market power? All that is to say, I don't think there are easy answers. I don't think there are easy answers. And I think and that sort of counsels in favor of keeping the law quite flexible rather than imposing prohibitions and do's and don'ts. So digital markets do change quickly, and we want to encourage that innovation. We want to encourage that disruption. I'll hand it back to you.
Thanks. Anyone else want to weigh in on this topic?
The only thing I would say on the flexible point, because I think I'm the only lawyer or person who's primarily a lawyer on this, is that we do have an unusual act structurally in that it contains both lots of detail and not lots of detail. And I'm all in favor of rationalizing the way we describe the rules and rationalizing how we determine thresholds for intervention. But I think some of the conversation is not about specifically prohibiting conduct. In fact, I wouldn't be in favor of that. But I think that unfortunately, and this is a little bit the product of our legal system, which is partly common law and partly civil law, is that common lawyers really like lists of things that identify things. And if it's not in the list, it doesn't get considered, which is, I think, one of the reasons why factors related to the digital economy were added in that list of factors for abuse of dominance and mergers in the last round of amendments in the spring. I would be inclined to say it should just be all relevant factors. But then people say, well, but that's too hard to define. So I am in favor of flexibility, but a different kind of flexibility. I find that what happens is we like this semi-precise, which allows us to exclude the things we don't like and to give more weight to things we do. So I'm a little bit cautious about the flexibility argument. The other thing I would say is I think the debate is not really about specific conduct being prohibited. It's about the thresholds required to establish that there's harm and the methods by which those should be proven. And I think that is the big elephant in the room, is who is best situated to provide the evidence, and is it best to tackle this in individual cases or through general powers, and that part I think is very important, what Tom talked about in terms of the market power study.
I'll just jump in too, if I could, for a second, Aaron, just to sort of say I agree with so much that I've heard from all my fellow panelists there. I think I land pretty much like Anthony in terms of a concern over sort of over-regulating a sector that is very dynamic. And he was building on points that Gail made that, a lot of these companies that are so big and dominant, they got there in part because they started offering us better stuff than we had, doing things that we didn't even know we needed to do, but now we can't live without. We want to encourage that kind of innovation, and this sort of the European approach of writing down a whole bunch of things that you can't do is a little bit scary. So I like the flexibility in our law as well, and would like to find ways to. There is the concern that if competition policy doesn't tackle some of this stuff, then there's going to be a whole new regulatory body created to attack it, and I'm not really excited about that prospect either. So I do think we have to engage in this debate and contribute to it. And hopefully, I think I would come out like Anthony. I like a kind of a very flexible system, and Jennifer's points on this flexibility, I think, are well taken as well. I did also want to flag one other thing that Jennifer said that I thought was really interesting, that Jennifer's opened up the topic of kind of the institutional structure we have for evaluating these cases. And she mentioned specifically a concern about the tribunal. I think there's a even wider set of sort of institutional elements that we might want to consider, like the role of private enforcement, which I sort of already mentioned, and the independence of the Bureau, which some have said is not what it should be in the current governmental structure that we have, and also an idea that's been brought up by past Commissioner Peckman and others, that maybe we need a competition commission or council in Canada to provide sort of broader advice about competitiveness in Canada that would help us to attack things like interprovincial barriers to trade, regulated industries that are not necessarily regulated in a very competitive friendly way, supply management and things like that, foreign ownership restrictions, all that kind of stuff. So I think there's a lot of interesting stuff we could talk about on the sort of institutional side as well.
Great. Gail.
Yes, one quick comment about the broader goals. That, you mentioned that we're trying to reach beyond competition to try to integrate more social goals into the framework of the law. It's another thing that brings me back to customer sovereignty. I think we have, a raise of awareness among citizens and customers that are taking responsibility about what they buy and from which company they buy it. And we used to talk about corporate social responsibilities, 10, 15 years ago. Now we talk about ESG, the environment and social goals. And there are standards that are being developed that companies can judge themselves or can be judged by customers or customer association as, how careful are they into the way they treat their employees and how they source their products and whether they are environmentally, aware or not. And these are the customers that are enforcing this now by buying or not buying products, from certain companies. So again, I would be more in favor of responsibilizing the customers and let them, and the companies or the association that they form define these standards and follow through. Just one example, the European Investment Bank, which is the biggest development bank in the world, is actually self-declared itself the climate change bank last year. And actually, they are very rigorous in the way they define their standards. And you see a lot of investment companies now also that take the claim and the stand of, trying to enforce some of these broader goal standards, inclusion and environmental friendly and so forth and so on, because that's the trend the customers are asking for, not because of some government decision on enforcement. So again, my personal inclination would be to, let the customers make their decision, have a debate, raise awareness about who they buy their product from. Traceability is a big issue. All these things come into the discussion when it comes to do we want to force companies to behave a certain way, like the prohibited conduct or forced conduct, or do we want to have the customers drive the market towards the direction that is more conscious and more inclusive of these values that are a big part of the new generation now.
Great, thank you. Tom, I wanted to come back to you. I mean, you had essentially made the argument that the Act generally works well. We have the tools we need. There might be some tweaks at the margin, and you proposed a few of those, including the market studies power. I guess to play devil's advocate a bit, I mean, a market studies power, would that not potentially open up the possibility of sort of fishing expeditions? And would you not have a lot of private businesses sort of saying, well, look, I'm prepared to hand over this data, which may be very valuable to me, this information, provided there's some sort of prima facie evidence that there's some wrongdoing going on? Or, I mean, is this a chicken and the egg problem? Is that, well, unless the Bureau has this information, they're not able to establish whether there's a problem in the first place? So I guess I just put it to you, would something like expanding the market power, so the power to do market studies, is that in fact keeping the Bureau and the Act focused, or is it in fact sort of launching them off into a whole new area?
Yeah, it's a great question, Aaron. I know that market studies got a very bad name after the petroleum inquiry back several decades ago, which cost a lot of money and didn't really turn up any evidence of ill doing or any substantial reforms that would make those markets work any better. And I was certainly not involved in any of that, and don't know much about what went on behind the scenes there. But I have been doing some work to study what other countries do in the market studies space, and almost all countries with advanced competition regimes have give their agencies stronger market studies powers than our bureau has. Our bureau, can do some studies, and they will brag about what they've done, and they deserve to. But generally, they need kind of a reason to do them. They have to be providing evidence before some government or another regulatory body, and so they can do a study to help them provide that evidence. And so they've had some workarounds that have allowed them to do things like open bank or fintech kind of studies and things like that. But it's very difficult for them to compel participation, which I think is very important, and which many countries allow that. Now, the point that you're hinting at, Aaron, is this could be a big, expensive fishing expedition, as I think maybe some people felt the petroleum inquiry was. But I think from my experience studying other countries, they've dealt with that by just putting restrictions on the conditions necessary to launch one of these. Even the launch can be subject to ministerial review, to make sure that there is a real reason for this to happen. I think there are ways to protect the process such that it doesn't become an expensive fishing expedition, and I think there's lots of examples of countries that have been doing this for some time with a great deal of success, and I'm sure we can follow those examples, learn from them, and develop a Canadian model. Australia, New Zealand have been acting. New Zealand more recently. South Africa's just jumped into it. Americans in some forms have been doing them through the FTC consultations. So lots of examples there that don't seem to be leading people to protest in the street about the expense of these studies. So I think we can get there. Now, one power that I wouldn't necessarily advocate, there are these different levels of market studies. There's some countries that don't allow anything like that, which is kind of close to where Canada is. We have to go through loopholes. There's some that would allow studies but without powers. Then there's studies with powers, and then there's there's a few countries that have even stronger powers where you can do a general study of an industry like telecommunications. And out of that study, even though it wasn't launched based on allegations against any particular firm, but just the outcome of your study can lead to orders to change behavior. Some countries have that. That's a very strong market study power, and I wouldn't go that far in Canada at this point. I would still leave the point of the market study is to understand how the market works, to better understand where there might be failures. And to me, one of the values of it is as a kind of a better step for us in the digital space than ex ante regulation. If we really do get concerned about, let's say, self-preferencing that Anthony talked about, self-preferencing in some sector, we could do a market study and look to see if we really do see any competitive effects of that behavior. And if as a result of that, we need new legislation or new regulations, we can do that. So I see market studies as a way for us to address, first of all, new challenges from the digital sector, where we've got markets that we maybe don't really completely understand because we didn't have them 20 years ago or 30 years ago. So that it's an outlet for us to study those without having to launch what could be an ill-fated case. But it's also true we could use market studies to poke other sections of government to take action. Market studies could be done that show how damaging foreign ownership restrictions are, for example, and push other governments. And part of the provisions of the market studies new powers could be that when a market study is published, other government agencies must be compelled to respond within 6 months to any action that they've been called to take based on this market study. And that is something that some countries do. And I think that's a way for us to get around some of the other competitiveness challenges we have in Canada. by drawing more attention to them and from a well-researched and largely independent government body. So I am a big fan of the market studies powers, and I'm sure we can find a Canadian way to do them that'll work.
Fair enough. I'm mindful we've got we only got about 10 minutes left, where time is just flying by here. If unless anyone has any other comments, I want to make sure we get a couple questions into the other panelists. And seeing none. Now, Jennifer, you raised a really interesting point about the fact that we've obviously inherited specific institutions to deal with competition policy, and you've hinted at the fact that you think there might need to be some changes there, and we want to restructure those institutions. So I'm wondering, are there any particular models that we should be looking at abroad, or what in your view would be a better way to set up enforcement?
Thanks, Aaron. I'll try to be brief on this. My sense is that what we've got right now is a tribunal. It's an administrative tribunal, but it's really like a court, and it uses the federal court rules, which are really the most formalistic and heavy rules that there are, with all the respect that's due to the federal courts. And I think that what's interesting is that any matters that can be heard by the regular courts, people rush to the regular courts. It shouldn't be that way. You should be preferring the expert tribunal because they should be faster and more expert. And I think it's partly that they're just encumbered with a very slow process. And the acceleration that was attempted in Roger Shaw, to me, this is the metaphor I gave in another forum, where I said, this is like making an elephant run. Okay, it's a little bit faster, but we need to think it, what's the entity. I think the Australian ACCC might be an interesting model to look at, even frankly, looking at how the Americans do things. I know they have a dual structure with the antitrust division and the FTC, but even just looking at the commission structure, I think that what's happening is that we need probably a more solid basis of expertise that draws on a bunch of areas, not just economics. I know that everyone on this panel is an economist, and I've done some economic studies as well. But I think there's more to competition policy and to competition enforcement than just economics and law, for that matter. And so I would like to have a broader basis of perspectives brought in there and expertise. And then I think that we need a process that's faster and that is not as beholden to some of the rituals of civil litigation. Now, it's an open question. Do people just want to, throw themselves out through private enforcement, as Tom has alluded, and just use the regular courts and live with the reality of civil litigation and figure, well, there's a certain pressure that things get done? I mean, the Americans do that a lot. There's a lot of private enforcement. But I just think that what we have right now is it brings together sort of elements that kind of make it the worst of both worlds: heavy, cumbersome, and not not really as expert as it could be. So, and I say that with the greatest of respect to everyone who's been part of the tribunal. It's just, I don't think it was structured well that way. I think the broader points that Tom raises about whether or not we need to integrate competition concerns and expertise on competition, defined broadly, into other government decision-making fora, I think is a very interesting one. And I actually think that an interesting development that's happening now is that the provinces are getting in on the act. They're starting to talk about getting involved at the local and provincial level in matters of markets and ensuring that competition is thriving. So I think that might be another way that we could expand and maybe reinforce the capacity to be responsive. I think that's the real issue here.
Okay. Gail, you've made the case for market forces here, and I wanted to touch on something, both because you are abroad and you have your previous experience, current experience in the telecom sector specifically. I did want to talk about foreign competition and the power of foreign competition and perhaps missed opportunities here in Canada, because it has seemed to me that most of the discussion surrounding changes to the Competition Act and updating competition law, that has sort of been left out of the conversation altogether. So I don't know what your views are on the role of foreign competition in Canada, what could be changed, whether it's specifically in telecoms or just more broadly.
Well, again, it's part of the same old debate on protectionism. Of course, again, what are we trying to achieve? if what we're trying to achieve is to get the Canadians the best value available for their money, division of labor being a worldwide phenomenon, yes, you want to give them the opportunity to have foreign operators doing better than the current domestic, challenging them to become better, and of course, foreign competition can be one of the vectors of improving value for money, better services, better quality for the Canadian consumers, or at least keeping the local domestic leaders on their toes, knowing that something can come from the outside. Going back to my original point, if we have a leader, overly dominant leader, but it's constantly increasing, improving value for money, for the customers is serving, then it deserves their loyalty. And competition find it hard to get in because this leader is constantly improving, its service, using less and less resource to create more and more value. And what else do we want? What more can we ask from the market? So yes, I believe that's definitely one way to improve the competitiveness and the value for the purchasing power in terms of quality and cost for the Canadians.
Okay. I'm interested to hear from others on the panelists too, because as a generalist, my impression is that a lot of the sectors where Canadians complain, I've already mentioned some of them, whether it's airlines, whether it's telecoms, whether it's banks, things like supply management. They do seem to be industries that are in large part shielded to some degree or another from foreign competition. So are my anecdotes a reflection of the reality? Is there is it a reality in Canada that the sectors where people tend to pay more and have less choice are those sectors that are more protected, or am I completely off base?
Well, I can jump in that. I don't think you're completely off base, Aaron. I think a lot of us would like to open the discussion about foreign ownership in these sectors. There is a little bit more to it than just sort of immediate consumer welfare. There are issues of the ability to. A lot of these sectors do require some regulatory control, whether it's telecommunications requiring interconnection or airlines requiring safety checks and that kind of a thing. And so there's sometimes a question of the ability of a domestic regulator to control foreign entities. But I think that has to be addressed on an industry by industry basis. Again, this is something that a market study could explore or a competition council could explore and take on to see what we could do. But you would like to think that the ability to have foreign participation in some of these markets could be beneficial. In telecom, I don't know, thinking wireless particularly, how much room there is for many more carriers. So it might just be foreign carriers would just buy up the Canadian ones and we'd still have 3 or 4. Now, maybe if there's a mixture of Canadians and Americans, it'd be still a bit more dynamic and not as cozy an oligopoly. But, there are economies of scale that might still limit the number of firms we have in some sectors. But it would at least be nice to have that discussion.
Yeah, absolutely.
Yeah, you have anecdotes and I have anecdotes too, Aaron. I pay many multiples of what my friends in the UK pay for their cell phone, like 8 to 10 times more. And I think Tom's exactly right that there is a lot of coziness in a lot of these industries that we have in Canada. I think it's, and this goes back to what Gail says: is what do we want this competition law to do? There's obviously these trade-offs that people are making. Personally, I would put a lot of weight on lowering prices, having more innovation in these sectors than obviously the weight that the government's putting on it right now.
I would just add that most of these sectors, it's a drum I've beat it before, are places where hard policy compromises have to be made about sovereignty, about national identity, about the things we value, about the things that make us different from other parts of the world, about where we benefit from foreign and other influences. You know, I mean, we live in a global world, but we also try to retain some sort of distinctiveness, and I think those are hard. Those are hard discussions to have. But I tend to agree with Tom that they should be looked at, and we should have some kind of mechanism or forum within which those debates can occur based on the evidence and not based on, you know, political rhetoric and whatever else is going on. I think it's time to have serious conversations, and we need to create the spaces to have those conversations, and then we can have good policy. Maybe it is time to open up to foreign competition, but I think we shouldn't take those decisions lightly. I think they need to be evidence-based and informed by an acknowledgement that you can't do everything. You will make choices. There are costs to everything.
Thank you, Jennifer. And I think you've probably outlined what's probably the most difficult for politicians to do, which is to acknowledge that there are trade-offs. They like to frame everything as a win-win, and there are no costs to any decision. But and as Gail mentioned earlier, if the goal of competition policy is to get cheaper stuff to consumers, it's pretty straightforward. But there are, of course, other considerations that you've laid out. So that hour really just flew by. I wish we had more time to get into everything. I want to thank all of you, Anthony, Tom, Gail, Jennifer, for joining me today. And I want to thank you, the audience, for tuning in. We'll see you next time on the next MLI webinar.